What's going on, guys? It's your man Ed Hayes here, back for another video, and in this one I want to briefly cover HB 2747. That's the new law out in Arizona that's going to require wholesalers out there to disclose to their buyers and their sellers that they are wholesalers. Okay, the reason why I'm making this video is because it actually goes into effect starting today, September 24th, the day that you're watching this video, the day that this video drops at least. So I want to go into the computer, actually show you what the language of the law looks like, so all of you all out there in Arizona, or people who are thinking about virtually wholesaling in Arizona, will be very, very aware and know exactly how to stay as compliant as possible out here. We don't want no problems. Okay, so let's not waste any time. Let's get right on into it.
Hey, coming down like precipitation. I ain't never met a...
All right, guys, so we are here on the actual website now, where you can see the actual law. So, and this basically just kind of breaks down exactly what's in the law. So I'm not going to hold you all here for too long, but basically the provisions of this law is basically saying that provision 1 is it requires a wholesaler buyer of residential real property before entering into a binding agreement to provide a disclosure in writing to the seller that the buyer is a wholesale buyer. So basically just saying that you have to tell the seller that you're a buyer in writing. Stipulates if a wholesale buyer violates the disclosure requirement, the seller may cancel the contract for sale at any time prior to the close of escrow without penalty and may retain any earnest money paid by the wholesale buyer. Meaning that if you don't tell them that you're a wholesaler, then you could miss out on your earnest money. So that could be pretty big, right? It also requires the wholesale seller of residential real property before entering into a binding agreement to provide a disclosure in writing to the buyer that the seller is a wholesale buyer who holds an equitable interest in the property and that the seller may not be able to convey title to the property. Basically saying, hey, look, I'm not the actual owner. I do hold an equitable interest, but there's a possibility that I may not be able to convey that title to you. Boom. Outside of that, it's saying, just so I don't have to read everything, it's basically saying that the buyer may cancel the contract for sale at any time prior to the closing as well without penalty and may retain any earnest money paid by the buyer. So that's basically, so, you know, on both ends, whether it's the sellers, whether it's the buyers, if you don't disclose everything, you put your earnest money at risk and you put the deal at risk in general. Both parties, the seller and the buyer, can back out of that deal if you do not disclose to them that you're a wholesale buyer or a wholesale seller in the state of Arizona. So guys, tell me, what do you all think about the new HB 2747? Are you in Arizona? Does this law actually affect you? Also, I'm curious, do you think that this law will start to get extended or used as kind of like a template for other markets? One of the biggest things that we have going on out here in the space is the disclosure aspect of everything. So I'm very curious if you all think that this could be a template that can be used in future situations to be able to kind of legislate what us wholesalers are able to do. Drop me a comment down below and let me know what you think about that. And also, if you like videos like this where I'm talking about wholesaling news, wholesaling laws, new things to pay attention to, definitely check out this playlist right here. There's going to be tons of other videos showing you how to get out here and stay away from the BS and the drama. We ain't got time for that. Anyway, though, guys, until next time.